Hello, my name is Stephanie. Thank you for joining me. If you've been following this video series, this is a continuation of our talk on IDEA Part B, and in this video we'll be talking about the mediation process. So we're going to start off with procedural requirements. IDEA states that state or local educational agencies that receive financial assistance under this law must have established procedures, including mediation, for dispute resolution that includes the following elements. 1. Procedures that ensure the mediation process is voluntary by all parties, is not used to deny or delay a parent's right to due process hearings, and is conducted by a qualified and impartial mediator who is trained in effective mediation techniques. The law requires that each state maintains a list of appropriate mediators who are knowledgeable regarding the laws and regulations related to special education and related services. IDEA specifies that mediation meetings need to be scheduled in a timely manner and that the state shall bear the cost of mediation. IDEA has provisions as well that require local and state educational agencies to offer schools and parents who don't want to pursue mediation the opportunity to meet with disinterested parties at the convenience of the parents. The purpose should be to explain the benefits and encourage the use of mediation. Should the school and parents come to an agreement through mediation, they have to establish a written document that states that all discussions that occurred through mediation will remain will remain confidential and may not be used as evidence in any subsequent due process hearings or civil proceedings. The agreement has to be signed by both the parent and a representative of an agency who has binding authority to actually make the agreement, and it has to be enforceable in any state or district court in the US. Once the parent files a complaint, a preliminary meeting between the parents and members of the IEP team with knowledge about the facts of the complaint has to occur within 15 days. A representative of the educational agency, who again has the decision-making power, has to attend this meeting. IDEA states that the district may not bring an attorney unless the parent requests to bring an attorney of their own first. Again, the goal is to resolve disputes collaboratively and as civilly as possible. At this meeting, parents will start by presenting the facts related to their complaint. The district then attempts to resolve the issue. If any agreement is made, it can be voided by either party within 3 business days. This meeting can also be waived altogether if both parties agree in writing or if they agree to pursue mediation instead. If the local educational agency and the parent can't reach resolution within 30 days of the complaint being filed, then due process hearings occur. Both parties have to share any evaluations and recommendations they plan to present with each other with at least 5 days prior to this hearing. IDEA gives the hearing officer authority to ban introduction of new materials unless the other party consents. The hearing officer can't be an employee of an educational agency that's involved with the child, and they can't have a personal or professional conflict of interest. Again, this is supposed to be an impartial person in the process. According to the law, they have to have the ability to understand the legal interpretations of IDEA and knowledge to conduct hearings and render and write appropriate decisions. The due process hearing is only for the complaint that's filed. IDEA is very specific in saying that a party that requests a hearing can't raise additional issues that weren't in the original complaint. Finally, the law states that a hearing has to be requested within 2 years of a violation unless a parent was prevented from filing due to the local educational agency falsely representing resolution of their complaint or the local educational agency not informing parents that they had a right to due process. On to the decision itself. So a hearing officer may determine that a child did not receive FAPE, again, that's free appropriate public education, only if procedural inadequacies impeded the child's right to FAPE, significantly impeded the parent's opportunity to participate in decision-making process regarding the provision of FAPE, or caused deprivation of educational benefits. IDEA states that any involved party may appeal the decision to the state. A state officer will then review findings and decisions and make an independent decision thereafter. During this process, any party has the following rights. 1. The right to be accompanied or advised by counsel and individuals with special knowledge and training with respect to children with disabilities. 2. The right, the right to present evidence and confront, cross-examine, and compel attendance of witnesses. And 3. The right to written, or at the option of parents, electronic, findings of facts and decisions. This also has to be made available to the public and transmitted to the advisory panel. Beyond an appeal, either party may pursue civil action if they're dissatisfied with final decisions in the state or district court. Parties then have 90 days following a hearing decision to raise such an action, unless an alternate timeline is set forth by the state. The court will receive records of administrative proceedings, hear additional evidence as requested by parties, and grant relief as deemed appropriate. The courts have the authority to grant reasonable attorney fees to the prevailing party if either party or their attorneys are pursuing litigation for inappropriate purposes, or if litigation is found to be frivolous or unreasonable. In any case, the court may grant fees to prevailing parents. So again, the whole point of the entire law is to ensure that children with disabilities really get a free and appropriate public education with all the supports and services that they need and deserve. Therefore, the cost of fighting for these rights should not be left to the parents. And as long as you as a parent are doing what you're supposed to be doing and following the procedures you need to and holding the school accountable, then ultimately the courts will likely fall on your side. So this concludes our discussion on the mediation process and actually completes our video series breaking down IDEA Part B. In the next series, we'll talk about Part C, which gets into early intervention services. Thanks for joining me.